The Second Amendment provides a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. We explained in Heller and MacDonald that the Second Amendment guarantees the individual right to possess and carry weapons in case of confrontation. We excluded from protection only those weapons not typically possessed by law-abiding citizens for lawful purposes, from Heller. And we stressed that the very enumeration of the right takes out of the hands of government, even the third branch of government, the power to decide on a case-by-case basis whether the right is really worth insisting upon, also from Heller. Instead of adhering to our reasoning in Heller, the Seventh Circuit limited Heller to its facts and read Heller to forbid only total bans on handguns used for self-defense in the home. All other questions about the Second Amendment, the Seventh Circuit concluded, should be defined by the political process and scholarly debate. But Heller repudiates that approach. We explained in Heller that since the case represented this court's first in-depth examination of the Second Amendment, one should not expect it to clarify the entire field. We cautioned courts against leaving the rest of the field to the legislative process. Quote, constitutional rights are enshrined with the scope they were understood to have when the people adopted them, whether or not future legislatures or, yes, even future judges think that scope too broad, close quote. Based on its crabbed reading of Heller, the Seventh Circuit felt free to adopt a test for assessing firearm bans that eviscerates many of the protections recognized in Heller and MacDonald. The court asked in the first instance whether the banned firearms were common at the time of ratification. But we said in Heller that the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. The Seventh Circuit alternatively asked whether the banned firearms relate to the preservation or efficiency of a well-regulated militia. The court concluded that state and local ordinances never run afoul of that objective, since states which are in charge of militias should be allowed to decide when civilians can possess military-grade firearms. But that ignores Heller's fundamental premise. The right to keep and bear arms is an independent individual right. Its scope is defined not by what the militia needs, but by what private citizens commonly possess. Moreover, the Seventh Circuit endorsed the view of the militia that Heller rejected. We explained that Congress retains plenary authority to organize the militia, not states. Because the Second Amendment confers rights upon individual citizens, not on state governments, it was doubly wrong for the Seventh Circuit to delegate to states and localities the power to decide which firearms people may possess. Lastly, the Seventh Circuit considered whether law-abiding citizens retain adequate means of self-defense and reasoned that the city's ban was permissible because if criminals can find substitutes for banned assault weapons, then so can law-abiding homeowners. Why would criminals obey the law? Continuing now with this dissent. Although the court recognized that Heller held that availability of long guns does not save a ban on handgun ownership, it thought that Heller did not foreclose the possibility that allowing the use of most long guns plus pistols and revolvers give householders adequate means of defense. But that analysis misreads Heller. The question under Heller is not whether citizens have adequate alternatives available for self-defense. Rather, Heller asks whether the law bans types of firearms commonly used for a lawful purpose, regardless of whether alternatives exist. And Heller draws a distinction between such firearms and weapons specially adapted to unlawful uses and not in common use, such as sawed-off shotguns. The city's ban is thus highly suspect because it broadly prohibits common semi-automatic firearms used for lawful purposes. Roughly 5 million Americans own AR-style semi-automatic rifles. It must be way more than that. The overwhelming majority of citizens who own and use such rifles do so for lawful purposes, including self-defense and target shooting. Under our precedents, that is all that is needed for citizens to have a right under the Second Amendment to keep such weapons. The Seventh Circuit ultimately upheld a ban on many common semi-automatic firearms based on speculation about the law's potential policy benefits. The court concluded that handguns, not assault weapons, are responsible for the vast majority of gun violence in the United States. Still, the court concluded the ordinance may increase the public's sense of safety, which alone is a substantial benefit. Heller, however, forbids subjecting the Second Amendment's core protection to a freestanding interest-balancing approach. This case illustrates why. If a broad ban on firearms can be upheld based on conjecture that the public might feel safer while being no safer at all, then the Second Amendment guarantees nothing. The court's refusal, meaning the Supreme Court's refusal, to review a decision that flouts two of our Second Amendment precedents stands in marked contrast to the court's willingness to summarily reverse courts that disregard our other constitutional decisions. There is no basis for a different result when our Second Amendment precedents are at stake. I would grant certiorari to prevent the Seventh Circuit from relegating the Second Amendment to a second-class right. And that was written by Justice Thomas with Justice Scalia in agreement, concurring with that dissent. All right, that's how Thomas felt last December. Now, the parties against the assault weapons ban are formally petitioning the U.S. Supreme Court for a writ of certiorari, which is how you ask the Supreme Court to review a law. The parties are, Caleb Barnett, petitioners versus Kwame Raoul, Attorney General of Illinois. So they're just suing the state of Illinois. Chuck Michael is one of the authors of this petition. If that name sounds familiar, it's because we just read a law review article last Friday, just published in the Wyoming Law Review by authored by Chuck Michael and good friend of the show, Costas Moros, both attorneys in California, work for the same firm, do a lot of great fighting in federal court, including all the way to the Supreme Court in defense of our Second Amendment rights. Some of this is, now both these documents, Justice Thomas's dissent and this petition, will be embedded in the Law Self-Defense blog post version of today's show. Much of this petition I'll skip because it's kind of administrative stuff, but it's still 20 or 25 pages of substance that we'll be reading. All right, so here is that petition. Supreme Court of the United States, Barnett versus Illinois. There's Chuck Michael. The question presented. In 2015, a divided Seventh Circuit panel held that states should be allowed to decide when civilians can possess firearms that they, the states, deem in their discretion to be military grade, so long as they leave their citizens with other adequate means of self-defense. This was the first Friedman versus Highland Park. The future author of New York State Rifle and Pistol Association v. Bruen, meaning Justice Thomas, lambasted that decision as flouting this court's precedents and relegating the Second Amendment to a second-class right. Yet after Bruen seemingly interred the reasoning of decisions like Friedman, killed, and Illinois responded not by conforming existing law to Bruen, but with defiance, banning upwards of 1,000 previously lawful rifles, pistols, and shotguns, plus their respective parts and common magazines. A divided panel of the Seventh Circuit that included Friedman's author resurrected Friedman, declaring its approach not only basically compatible with, but more useful than Bruen, which it derided as a slippery, circular, and not very helpful opinion by the Supreme Court. See what's happening here, folks? The lower Seventh Circuit is just deciding that they don't like the Supreme Court's decision in Bruen.